let's just have an overview of what the biodiversity-related conventions are. There are actually 7 of them, and one I haven't listed there is the International Plant Protection Convention that has to do with plant pests. But otherwise, the traditional conventions we are looking at, many are originated from the 70s, and they either take a species-based approach. CITES, the Convention on International Trade in Endangered Species, has that approach, but the same idea, the same type of international regulation is found in the Convention on Migratory Species. So the international community together identified a concern and lists species that require particular forms of cooperation at the international level. In the context, instead of site area-based conventions, we have the Ramsar Convention on Wetlands of International Importance and the World Heritage Convention. Again, we have a similar listing approach. So in both cases, parties identify particular areas that are listed under the conventions and that require particular forms of international cooperation. What we see is that if we look at those 4 treaties which have different histories and different membership, we have a system that, of course, systems that speak to each other and may contribute to each other's objectives, but even if we sum up all of their efforts, it's still somehow a patchwork. We don't have necessarily full protection of nature. We may have quite a few gaps in between. And this is the reason why in the early 90s, the international community negotiated the Convention on Biological Diversity with a view to move towards a holistic approach to the conservation of nature, perhaps a more also subtle understanding of what nature is from a scientific perspective, and really pushing the international community as a whole and then action at the national level to really look at the variability of life on Earth, not necessarily just certain species, not necessarily just certain areas or habitats for how important they may be, but really the fact that the whole of their existence, their complex interactions are what should be the common concern of humankind. Now the convention has been developed into 2 protocols, the Cartagena Protocol on Biosafety and the Nagoya Protocol on Access and Benefit Sharing. I think we've heard a little bit about the compliance procedures under the Cartagena Protocol, and I won't really discuss this during the hour we have together, partly because in some ways I think the procedures are quite similar to what we've just heard from, for instance, some of the chemicals conventions, and partly because there haven't been any submissions to the committee, so in some ways it hasn't been quite active, at least in the classic sense of receiving submissions. There was one case where an NGO made a submission, but the committee considered it not acceptable because it wasn't really, an NGO trigger was not foreseen in the procedures. But the Cartagena Protocol Committee is meeting, and it is looking at systemic issues of compliance. So there is some activity there. But I thought that perhaps in concluding, we can rather look at the novel features of the compliance procedures that have been adopted most recently under the Nagoya Protocol on Access to Genetic Resources and Benefit Sharing, just because that aspect of non-state actors is addressed in quite a novel way in the context of those procedures. The last treaty is the International Treaty on Plant Genetic Resources for Food and Agriculture. It's a treaty that's very much been modeled according to the objectives of the CBD, and focuses very much on a specific sector in relation also to access and benefit sharing through a multilateral system. It has its own compliance mechanism, which has some interesting features in terms of the Secretariat and the committee taking certain initiatives in looking at potential issues, but also providing advice, including legal advice where necessary.